Hello everyone. In this session, we will be talking about private mediation. In the previous sessions, we have discussed about pre-litigation mediation, post-litigation mediation, and various other types of mediation. So today's talk will revolve around private mediation. In the 1980s, private mediation caught on when insurance companies realized the cost benefits of resolving insurance claims informally and expeditiously. So this is when private mediation started gaining importance. This was when in 1980s when the insurance companies realized that mediation is an effective tool to resolve the disputes, the insurance claims informally and very fast, that is expeditiously. Private mediation took hold in a variety of ways, including the emergence of private or independent mediators, non-profit mediation programs and agencies, and for-profit mediation providers. So, private mediation came along with private mediation came along different trends which included private and independent mediators or non-profit mediation programs and agencies, and for-profit mediation providers. Private mediation was applied to pre-litigation disputes, litigated disputes, and very recently it has started applying to commercial as well as international disputes. In private mediation, qualified mediators offer their services on a private for a fee for service basis to the court, to members of the public, to members of the commercial sector, and also to governmental sector to resolve disputes through mediation. Private mediation can be used in connection with the disputes pending in the court and pre-litigation disputes. So what happens in private mediation is that the private mediator provides its services, his or her services, on the fee for service basis. The service here being mediation service. And with this mechanism, with the help of private mediation, it can be helpful for the members of the public, members of commercial sector, members of the government sector also. So, private mediation has been very helpful in all these disputes, and it is not restricted to only post litigation disputes. It is also open for pre litigation disputes. In private mediation, the parties can agree to treat their settlement agreement as conciliation agreement, which then will be governed by the provisions of the Arbitration and Conciliation Act of 1996. So the parties can agree and they'll be treating their settlement agreement, which they'll arrive by means of mediation, as a conciliation agreement which has its validity in Arbitration and Conciliation Act of 1996. In private mediation, a qualified mediator is appointed by the parties on a fixed fee basis. Next is that both the parties come together to resolve their issues amicably, and a mediator can be of any designation and anyone can appoint them to resolve their disputes through private mediation. So the important takeaway here is that the mediator, private mediator, he's appointed by the parties and he's appointed on a fixed fee basis, and he can be of any designation and he's brought in to resolve the disputes amicably. It is a time-saving mechanism and gives various creative outcomes for parties to choose from. The decision of the mediator is not ultimate and hence not binding on the parties. So, when we talk about private mediation, the decision of the mediator would not be ultimate and it would not be binding on the parties unless the parties they agree to it and they want to go ahead with it and make it convert it into a settlement agreement. Now, there are certain myths and realities which revolve around private mediation. People have a lot of misconceptions about how private mediation works and whether the decision which comes from decision or the outcome which comes from private mediation, it is binding or not. So there are a lot of myths attached to it. So now we'll be dealing with those myths and we'll be seeing what reality actually would look like. So the myth here is attending private mediation is a waiver of right to pursue further legal action in court. That is, people believe that if we attend private mediation, then we waive our right to pursue a legal action in court. And what the reality is that the procedure of private mediation is voluntary. The ultimate objective is to facilitate the parties' amicable resolution through communication and interaction. If mediation is unsuccessful, that is, the parties are unable to come to a mutually agreeable agreement, the parties may choose to go before the courts to exercise their legal rights and remedies. In India, disputants are not prohibited by law from going to court simply because they have attended mediation. In reality, it is strongly encouraged that the parties should exhaust all informal channels of conflict resolution before resorting to a formal legal action. So, when we talk about the reality, the fact is that mediation is a voluntary process, and even if the mediation does not come out to be successful, then the parties have the right to go before the court and get their dispute resolved. In real life, it is actually promoted that the parties should first exhaust the informal channels, other alternate dispute resolution mechanisms, before resorting to any court process. Next myth revolving around private mediation is that legal advisors are not welcome in private mediation since it is an anti-lawyer practice. Now we'll be talking about the reality. The fact is that lawyers are a very active part of the private mediation process. Lawyers who are active in litigation or arbitration still play a very crucial role in mediation. Lawyers introduce mediation as a potential conflict management system to clients when they approach them. Lawyers aid in selecting the best mediator for the situation, focusing attention on pertinent information and decision makers, deconstructing the complicated conflict, and streamlining the concerns to improve a quick resolution through mediation. During the mediation process, lawyers counsel their clients on how to express their goals, their strategies, demands, and concessions. Any agreement reached during mediation will, of course, also need to be reviewed and written into a settlement agreement. Although there is no obligation for parties to bring a lawyer to the mediation table, mediators encourage the parties to have sound legal counsel before making and accepting offers. So, when we talk about the reality, when we do a fact check of it, we'll see that there is no such thing that mediation is an anti lawyer practice. In fact, lawyers are the people who introduce the parties to this ADR mechanism. They recommend the parties to go for mediation. They introduce mediation to them and they let them know that how mediation would be helpful in their conflict situation. They'll make an endeavor to decomplicate their complicated situation of conflict. Also, they will counsel their clients as to how can they express about their needs or what they actually want, what are their expectations. Also, if there is any agreement which is reached out for at towards the end of the mediation process, it needs to be reviewed and written into a settlement agreement. So when we see that when we have to see at private mediation, we obviously we know that there's no obligation on the parties to bring a legal counsel along with them, but it is strongly recommended that the parties bring in a legal counsel to consult with them before accepting any offer. The next myth, which revolves around private mediation, is that a private mediation settlement is not recognized by courts if the parties dishonor terms. Whereas, when we look at the fact or the reality is, In India, although there is no dedicated legal framework or legislation governing private mediation or settlements reached through private mediation, there are enough legislations already in place giving validity to a mediated settlement reached through a private mediation process. Very often, private commercial mediation in India leans on the procedural framework of conciliation, which is governed under Part 3 of the Arbitration Act. A settlement agreement arrived at through this mechanism is enforceable as a conciliator's award under Section 74 of the Arbitration and Conciliation Act, provided the procedure prescribed under the Arbitration Act is followed. Alternatively, if the parties enter into a privately mediated settlement agreement during the arbitral proceedings, then under Section 30, Clause 4 of the Arbitration Act, the settlement agreement is granted the status of an arbitral award which can be enforced under Section 36 of that Act. So, when we talk about the reality here, it is not that the private mediation is not recognized by courts, and if the parties will dishonor the terms, then so and so will happen. Whereas the reality is that there are enough legislations in place which give validity to even mediated settlements which come from private mediations. Now, what happens is the procedural aspect of the private mediation is more more often similar to the conciliation framework that has been provided under the Arbitration and Conciliation Act. And if any settlement agreement is reached, it would be having the same status as an arbitral award or a conciliation award has under Section 74, and it would be binding such as an arbitral award is. In addition, it stipulates that the settlement reached in accordance with Section 12A shall have the same legal force and effect as an arbitral award on mutually agreed conditions under Section 30 plus 4 of the Arbitration Act, which may be enforced in accordance with Section 36 of the Act. That is, it will have the same force as an arbitral award. Additionally, a settlement reached through private mediation has the same legal standing and enforceability as a contract, is defined in Section 2, Clause H of the Indian Contract Act of 1872, which states that the contract is an agreement enforceable by law. So, additionally, if we divert ourselves from the Arbitration and Conciliation Act and we move towards the Indian Contract Act, then we see that the settlement agreement and that is reached at after the conclusion of the private mediation process, it can have the status enjoyed by the term contract under the Indian Contract Act, which is defined as an agreement which is enforceable by law. The conditions of private mediation settlement agreement can therefore be enforced by turning to the appropriate Contract Act provisions if it passes the test of being a legally enforceable contract. So, if the mediation settlement passes the test of being a contract as defined under the Indian Contract Act, then the same repercussions uh, will be there for the dishonoring of the terms of the mediation settlement. That is, the same repercussions that are faced during the breach of contract as provided under the Indian Contract Act. Another myth which is attached to private mediation is that since private mediators have not been trained by the court does not recognize them. Whereas when we talk about the reality, it says that in private mediation, the parties jointly decide the name of the third party mediator depending on how comfortable and trusted they feel with them. There is presently no legal need that the private mediator gets training from the court. Furthermore, even the draft mediation bill of 2021 does not contain any such clause. In private mediation, parties typically select a mediator in accordance with the conditions outlined in the contract's mediation clause or at the mutual discretion of the parties. Parties sign into a legally enforceable settlement agreement once the dispute has been resolved. As long as the agreement entered is with the consent of the parties and is legally enforceable, the qualifications and accreditations of the mediator has no bearing on the recognizability of the settlement. So when we talk about private mediation, at present, there is no such statutory requirement that a private mediator needs to have some training from the court. But uh, having said that, we also should see that as long as the agreement, the settlement agreement, which is arrived at by the parties, as long as it has the consent of the parties and it is legally enforceable, the qualifications and accreditations of the mediator would not be of any weightage. However, it is advisable that before selecting a mediator, parties and counsel conduct an in-depth study to understand their training, background, experience, and cultural orientation. Ideally, and in accordance with widely acknowledged and approved international standards, the private mediators should have successfully completed at least 40 hours of training program offered by reputable organizations. So, though it is not a statutory requirement, but still it is advisable that once the parties opt for a private mediator, they should conduct an in depth study of the background, the cultural experiences, the training, and it is advisable that the person should have gone for a 40-hour training program which is offered by a reputable organization. Private mediators do not necessarily have to be advocates. They can also be professionals in business and management, education, medicine, art, social work, engineering, and other fields. So it is not required that they have to be advocates. They can be from the field of education, from the field of medicine, artwork, etc. Next myth which is attached to private mediation is corporations and businesses must file a lawsuit before considering mediation. Whereas the fact is that it is not necessary to initiate any legal action before seeking mediation. Any time is a good time to start a mediation. Before initiating a lawsuit, after the parties have failed to agree to reach at a settlement through negotiation, after the case has already been filed in the court, or even later. If the mediation is required under the parties' legal agreement, it would be sought before bringing a lawsuit. If not, the parties may mutually decide at any moment to submit their disagreement for mediation to be settled in accordance with the guidelines established by the mediation institution of their choice. So, it is not mandatory for any lawsuit to be instituted before going for mediation. Any time would be a good time to go for mediation, and if the parties the legal agreement between the parties requires them to go for mediation, then they are required to opt for mediation even before filing a lawsuit. Else, it is on the parties whenever they mutually decide to go for the mediation process, they can opt for it. Next myth is about that once arbitration proceedings have started, there is no room for private mediation. This does not hold this does not hold any truth in terms of reality. When we talk about the facts, an arbitral tribunal may, with the approval of the parties, adopt mediation, conciliation, or any other method at any point throughout the arbitral proceedings to facilitate settlement according to Section 30 of the Arbitration and Conciliation Act, which controls the alternative dispute resolution mechanisms in India. This clause encourages resolution by mutual consent of the parties and does not render any arbitration agreement incompatible. If the parties resolve their differences during the arbitral process, the tribunal will end the arbitration, and if the parties so wish and the arbitral tribunal does not object to it, it will record the conditions of the settlement in the form of an arbitral award on the agreed terms. So, what we are going through here is that the arbitral tribunal may approve the parties to go for mediation at any point throughout the proceedings, and if in between they go for mediation and they resolve their dispute by means of mediation, then if the parties wish, they can come back to the tribunal, and if the tribunal also does not object, they can get that agreement between them to be come forth in the form of an arbitral award, to get enforced in the form of an arbitral award on the terms that has been agreed by the parties. Recently, courts have established ARB-MED framework in the Indian justice delivery system by referring parties to private mediation while appointing an arbitrator under Section 11 of the Act. So we have already discussed about the ARP-MED framework under the in the previous classes, which is a hybrid of arbitration and mediation. So this has also started gaining momentum recently. Next myth which revolves around mediation is that according to the law, settlement agreements reached through mediation must be registered with the court and kept in a depository. Whereas the fact is that any mediation settlement agreement reached out through mediation in a pre-litigation situation is fully confidential and is only known to the parties, their lawyers, and the mediator. Most private mediators and mediation centers follow a standard procedure of refusing to sign the mediation settlement agreement even as a witness, so as it is entirely the parties' agreement and the mediator has no control over it. No third party may obtain information about the mediation settlement agreement, not even the knowledge that the parties have opted for mediation, that is the knowledge for mediation that the mediation has taken place. So what we are looking at here is that the mediation which is done by private mediators, even that is fully confidential, even they do not even they do not sign on the mediation settlement agreement even as a witness, and the whole agreement is kept very confidential, and even the knowledge that mediation has taken place is not given outside. This is all we need to learn about private mediation for now. I hope you enjoyed the session. Thank you.